Okay, I'm going to read the Christian Legal Society chapter of the University of California, Hastings College of the Law versus Martinez from 2010 in my constitutional law book on page 1618. Justice Ginsburg delivered the opinion of the court. In a series of decisions, this court has emphasized that the First Amendment generally precludes public universities from denying student organizations access to student activities at public universities. May a public law school condition its official recognition of a student group and the attendant use of school funds and facilities on the organization's agreement to open eligibility for membership and leadership to all students, is the question in this case. In the view of petitioner, Christian Legal Society, an accept all comers policy impairs its First Amendment rights to free speech on pain of relinquishing the advantages of recognition, expressive association, I should say, and the free exercise of religion by prompting it, on pain of relinquishing the advantages of recognition, to accept members who do not share the organization's core beliefs about religion and sexual orientation. From the perspective of respondent, Hastings College of Law, Hastings, or the law school, CLS, seeks special dispensation from an across-the-board open access requirement designed to further the reasonable educational purposes underpinning the school's student organization program. In accord with the District Court and Court of Appeals, we reject CLS's First Amendment challenge. Compliance with Hastings' all-comers policy, we conclude, is a reasonable viewpoint-neutral condition on access to the student organization forum. In requiring CLS, in common with all other student organizations, to choose between welcoming all students and foregoing the benefits of official recognition, we hold Hastings did not transgress constitutional limitations. CLS, it bears emphasis, seeks not parity with other organizations, but a preferential exemption from Hastings policy. The First Amendment shields CLS against state prohibition of the organization's expressive activity, however exclusionary that activity may be, but CLS enjoys no constitutional right to state subvention of its selectivity. Through its registered student organization, RSO program, Hastings extends official recognition to student groups. Several benefits attend this school-approved status. RSOs are eligible to seek financial assistance from the law school, which subsidizes their events using funds from a mandatory student activity fee imposed on all students. RSO may also use law school channels to communicate with students. They may place announcements in a weekly Office of Student Services newsletter, advertise events on designated bulletin boards, send emails using a Hastings organization address, and participate in an annual student organizations fair designed to advance recruitment efforts. So these are all benefits. In addition, RSOs may apply for permission to use the law school's facilities for meetings and office space. Finally, Hastings allows officially recognized groups to use its name and logo. In exchange for these benefits, RSO must abide by certain conditions. Only a non-commercial organization whose membership is limited to Hastings students may become an RSO. A prospective RSO must submit its bylaws to Hastings for approval, and if it intends to use the law school's name or logo, it must sign a release agreement. Critical here, all RSOs must undertake to comply with Hastings policies and regulations applying to college activities, organizations, and students. The law school's policy on non-discrimination policy, which binds RSOs, states, Hastings is committed to a policy against legally impermissible, arbitrary, or unreasonable discrimination practices. All groups, including administration, faculty, student governments, Hastings owns student residence facilities, and programs sponsored by Hastings are governed by this policy of non-discrimination. Hastings' policy on non-discrimination is to comply fully with applicable law. Hastings shall not discriminate lawfully on the basis of race, color, religion, national origin, ancestry, disability, age, sex, or sexual orientation. This non-discrimination policy covers admission, access, and treatment in Hastings-sponsored programs and activities. Hastings interprets the non-discrimination policy as it relates to the RSO program to mandate acceptance of all comers. School-approved groups must allow any student to participate, become a member, or seek leadership positions in the organization regardless of her status or beliefs. Other law schools have adopted similar all-comers policies. From Hastings' adoption of the non-discrimination policy in 1990 until the events during this litigation, no student organization at Hastings has sought an exemption from the policy. In 2004, CLS became the first student group to do so. At the beginning of the academic year, the leaders of the predecessor Christian organization, which had been an RSO at Hastings for a decade, formed CLS by affiliating with the National Christian Legal Society, CLS National. CLS National, an association of Christian lawyers and law students, charters student chapters at law schools throughout the country. CLS chapters must adopt bylaws that require members and officers to sign a statement of faith and to conduct their lives in accord with prescribed principles. Among those tenets is the belief that sexual activity should not occur outside marriage between a man and a woman. CLS thus interprets its bylaws to exclude from affiliation anyone who engages in unrepentant homosexual conduct. CLS also excludes students who hold religious convictions different from those of the Statement of Faith. On September 17th, 2004, CLS submitted to Hastings an application for RSO status accompanied by all required documents, including the set of bylaws mandated by CLS National. Several days later, the law school rejected the application. CLS bylaws, Hastings explains, did not comply with the non-discrimination policy because CLS barred students based on religion and sexual orientation. CLS formally requested an exemption from the non-discrimination policy, but Hastings declined to grant one. To be one of our student-recognized organizations, Hastings reiterated, CLS must open its membership to all students irrespective of their religious beliefs or sexual orientation. If CLS instead chose to operate outside the RSO program, Hastings stated the school would be pleased to provide CLS the use of Hastings facilities for its meetings and activities. CLS would also have access to chalkboards and generally available campus bulletin boards to announce its events. In other words, Hastings would do nothing to suppress CLS's endeavors, but neither would it lend RSO level support to them. Refusing to alter its bylaws, CLS did not obtain RSO status. It did, however, operate independently during the 2004-2005 academic year. CLS held weekly Bible study meetings and invited Hastings students to Good Friday and Easter Sunday church services. It also hosted a beach barbecue, Thanksgiving dinner, campus lecture on the Christian faith and the legal practice, several fellowship dinners, an end-of-year banquet, and other informal social activities. Before considering the merits of CLS's constitutional arguments, we must resolve a preliminary issue. CLS urges us to review the non-discrimination policy as written, prohibiting discrimination on several enumerated bases, including religion and sexual orientation, and not as a requirement that all RSOs accept all comers. The written terms of the non-discrimination policy, CLS contends, target solely those groups whose beliefs are based on religion or that disapprove of particular kind of sexual behavior, and leave other associations free to limit membership and leadership to individuals committed to the group's ideology. For example, a political group can insist that its leaders support its purposes and beliefs. CLS alleges, but a religious group cannot. CLS's assertion runs headlong into the stipulation of facts it jointly submitted with Hastings at the summary judgment stage. That in filing, the parties specified, Hastings required that registered student organizations allow any student member to participate become a member or seek leadership positions in the organization regardless of her status or beliefs. Thus, for example, the Hastings Democratic Caucus cannot bar students holding Republican political beliefs from becoming members or seeking leadership positions in the organization. Factual stipulations are binding and conclusive, and the facts stated are not subject to subsequent variation. So the parties will not be permitted to deny the truth of the facts stated, or to maintain a contention contrary to stated statement, or to suggest on appeal that the facts were other than as stipulated, or that any material fact was omitted. This court has accordingly refused to consider a party's argument that contradicted a joint stipulation entered at the outset of the litigation. Time and again, the dissent races away from the facts to which CLS stipulated, but factual stipulations are formal concessions that have the effect of withdrawing a fact from issue and dispensing wholly with the need for proof of the fact. Thus, a judicial admission is conclusive to the case. In the case, in light of the joint stipulation, both the District Court and the Ninth Circuit trained their attention on the constitutionality of the all-comers requirement, as prescribed in the parties' accord. We reject CLS's unseemingly attempt to escape from the stipulation and shift its target to Hastings' policy as written. This opinion therefore considers only whether conditioning access to a student organization forum on compliance with an all-comers policy violates the Constitution. In support of the argument that Hastings' all-comers policy treads on the First Amendment rights of speech and expressive association, CLS draws on two lines of decisions. First, in a progression of cases, this court has employed forum analysis to determine when a governmental entity in regulating property in its charge may place limitations on speech. Is that the appeal? And this is an analogy. This whole factual stipulation binding conclusive thing, I think it's being said that on appeal that the decision in the lower courts was not fair. Maybe because it didn't stay focused on the issues, but I've never read anything quite like that before. First, and then they restated the focus so that they would isolate on the focus, and the rule again being First Amendment rights to free speech and expressive association. CLS draws on two lines of decisions. First, in the progression of cases, this court has employed forum analysis to determine when a governmental entity, this is the analysis, in regulating property in its charge may place limitations on speech, recognizing a state's right to preserve the property under its control for the use to which it is lawfully dedicated. The court has permitted restrictions on access to a limited public forum. Like the RSO program here, with this key caveat, any access barrier must be reasonable and viewpoint neutral. Second, as evidenced by another set of decisions, this court has rigorously reviewed laws and regulations that constrain associational freedom. So this is the infringement in, I guess, test 1 or 2. In the context of public accommodations, we have subjected restrictions on that freedom to close scrutiny. Such restrictions are permitted only if they serve compelling state interests that are unrelated to the suppression of ideas that cannot be advanced through significantly less restrictive means. Freedom of association, we have recognized, plainly presupposes a freedom not to associate. Insisting that an organization embrace unwelcome members, we have therefore concluded directly and immediately affects associational rights. And so they've kind of stated the whole test there, and the outcome is that there is indeed an infringement on associational rights, an effect on associational rights. CLS would have us engage each line of cases independently, but its expressive association and free speech arguments merge. Who speaks on its behalf? CLS reasons colors what concept is conveyed. It therefore makes little sense to treat CLS's speech and associational claims as discrete. Instead, three observations lead us to conclude that our limited public forum precedents supply the appropriate framework for assessing both CLS's speech and association rights. First, the same considerations that have led us to apply a less restrictive level of scrutiny to speech in limited public forums as compared to other environments apply with equal force to expressive association occurring in limited public forums. As just noted, speech and expressive association rights are closely linked. Second, closely related, the strict scrutiny we have applied in some settings to laws that burden expressive association would, in practical effect, invalidate a defining characteristic of limited public forums. The state may reserve them for certain groups. Third, this case, so that must be the second. Okay, so we've got a first and a second. I'm missing the point. And third, this case fits comfortably within the limited public forum category for CLS in seeking what is effectively a state subsidy, faces only indirect pressure to modify its membership policies. CLS may exclude any person for any reason if it forgoes the benefits of official recognition. The expressive association proceedings on which CLS relies, in contrast, involve regulations that compelled a group to inward unwanted members with no choice to opt out. In diverse contexts, our decisions have distinguished between policies that require action and those that withhold benefits. So, require action versus withholding benefits are treated a little differently. In some, we are persuaded that our limited public forum, so it's not really an infringement because they can do it without, they can organize without being recognized. Can organize without benefits. In sum, we are persuaded that our limited public forum proceedings adequately respect both CLS's speech and expressive association rights and fairly balance those rights against Hastings' interests as property owner and educational institution. We turn to the merits of the instant dispute, therefore, with the limited public forum decisions as our guide. So this whole page is kind of reaching an analysis. Limited public forum analysis, which I think we're going to go through in the next 2 pages. We first consider whether Hastings' policy is reasonable taking into account the forum's function and all the surrounding circumstances. Our inquiry is shaped by the educational context in which it arises. First Amendment rights, we have observed, must be analyzed in light of the special characteristics of the school environment. This court is the final arbiter of the question whether a public university has exceeded constitutional constraints, and we owe no deference to universities when we consider that question. Cognizant that judges lack the on-the-ground expertise and experience of school administrators, however, we have cautioned courts in various contexts to resist substituting their own notions of sound educational policy for those of school authorities which they review. A college commission and concomitant license to choose among pedagogical approaches is not confined to the classroom, for extracurricular programs are today essential parts of the educational process. Schools, we have emphasized, enjoy a significant measure of authority over the type of officially recognized activities in which their students participate. We therefore approach our task with special caution. Oh my God. Mindful that Hastings' decisions about the character of the student group program are due decent respect. With appropriate regard for school administrators' judgment, we review the justification Hastings offers in defense of its all-comers requirement. All-comers requirements. First, the open access policy ensures that leadership, educational, and social opportunities afforded by the by RSOs are available to all students. Just as Hastings does not allow its professors to host classes open only to those students with a certain status or belief, the law school may decide reasonably, in our view, that the educational experience is best promoted when all participants in the forum must provide equal access to all students. RSOs we count it significant are eligible for financial assistance drawn from mandatory student activity fees, and all-comer policy ensures that no Hastings student is forced to fund a group that would reject her as a member. Second, the all-comers requirement helps Hastings police the written terms of its non-discrimination policy without inquiring into an RSO's motivation for membership restrictions. To bring the RSO program within, so it's kind of not content-based. I think that's where we're getting. To bring the RSO program within CLS's view of the constitutional limits, CLS proposes that Hastings permit exclusion because of belief but forbid discrimination due to status. But the proposal would impose on Hastings a daunting labor. How should the law school go about determining whether a student organization cloaked prohibited status exclusion in belief-based garb? If a hypothetical male superiority club barred a female student from running for its presidency, for example, how could the law school tell whether the group rejected her bid because of her sex or because by seeking to leave the club she manifested a lack of belief in the fundamental philosophy? Third, the law student reasonably adheres to the view that an all-comers policy, to the extent it brings together individuals with diverse backgrounds and beliefs, encourages tolerance, cooperation. So this is its interest of the school. Diverse backgrounds and beliefs encourages tolerance, cooperation, and learning among students. And if a policy sometimes produces discord, Hastings can rationally rank among RSO program goals development of conflict resolution skills, toleration, and readiness to find common ground. Fourth, Hastings policy, which incorporates, in fact, subsumes state law prescriptions on discrimination, conveys the law school's decision to decline to subsidize with public monies the benefits conduct of which the people of California disapprove. In sum, the several justifications Hastings asserts in support of its all-comers requirement are surely reasonable in light of the RSO's forum purposes. The law school policy is all the more creditworthy in view of the substantial alternative channels that remain open for the, there are substantial alternative channels, which is another test, that remain open for CLS communication to take place. If restrictions on access to limited public forum are viewpoint discriminatory, the ability of a group to exist outside the forum would not cure the constitutional shortcoming. But when access barriers are viewpoint neutral, our decisions have counted it significant that other available avenues for a group to exercise its First Amendment rights lessens the burden created by those barriers. In this case, Hastings offered CLS access to school facilities to conduct meetings and use the chalkboards and generally available bulletin boards to advertise events. Although CLS would not take advantage of RSO's specific methods of communication, the advent of electronic media and social networking sites reduces the importance of those channels. Private groups, from fraternities and sororities to social clubs and secret societies, commonly maintain a presence at universities without official school affiliation. Based on the record before us, CLS was similarly situated. It hosted a variety of activities the year after Hastings denied it recognition, and the number of students attending those meetings and events doubles. The variety and type of alternate modes of access present here. In short, compare favorably with those in other limited public forum cases where we have upheld restrictions on access. CLS also assails the reasonableness of the all-comers policy in light of the RSO forum's function by forecasting that the policy will facilitate hostile takeovers if organizations must open their arms to all. CLS contends saboteurs will infiltrate groups to subvert their mission and message. The supposition strikes us as more hypothetical than real. CLS points to no history or prospect of RSO hijacking at Hastings. Students tend to I don't know what we're talking about now because it's like outside of the test. So it's evidence of another restriction on free speech. Students tend to self-sort and presumably will not in Denver en masse to join, let alone seek leadership positions in groups pursuing missions wholly. I think it has to do with actually impact. So is this an impact analysis? This paragraph here talking about their membership outside of recognition of the school. So let alone seek leadership positions in groups pursuing missions wholly at odds with their personal beliefs, and if a rogue student intent on sabotaging the organization's objectives nevertheless attempted to take over, the members of that group would likely not elect her as an officer. RSOs, moreover, in harmony with the all-comers policy, may condition eligibility for membership and leadership on attendance, payment of dues, and other neutral requirements designed to ensure that students join because of their commitment to a group's vitality, not its demise. Hastings, furthermore, could reasonably expect more from its law students than the disruptive behavior CLS hypothesizes, and to build this expectation into its educational approach. A reasonable policy need not anticipate and preemptively close off every opportunity for avoidance or manipulation. If students begin to exploit an all-comers policy by hijacking organizations to distort or destroy their missions, Hastings presumably would revisit and revise its policy. So it's short on evidence of a negative impact. We next consider Hastings' all-comer policy as viewpoint neutral, although this aspect of limited public forum analysis has been constitutional sticking point in our prior decisions, as earlier recounted. So this is issue 2. We're about to analyze. It is, after all, hard to imagine a more viewpoint neutral policy than one requiring all student groups to accept all comers. Conceding that Hastings' all-comers policy is nominally neutral, CLS attacks the regulation by pointing to its effect. The policy is vulnerable to constitutional assault. CLS contends because it systematically and predictably burdens most heavily those groups whose viewpoints are out of favor with the campus mainstream. Even if a regulation has a differential impact on groups, wishing to enforce exclusionary membership policies where the state does not target conduct on the basis of its expressive content, acts are not shielded from regulation merely because they express a discriminatory idea or philosophy. Hastings' requirement that student groups accept all comers, we are satisfied, is justified without reference to the content or viewpoint of the regulated speech. The law school's policy aims at the act of rejecting would-be group members without reference to the reasons motivating the behavior. Hastings' desire to redress the perceived harms of exclusionary membership policies provides an adequate explanation for the all-comers condition, over and above mere disagreement with any student group's beliefs or biases. CLS's conduct, not its Christian perspective, is, from Hastings' vantage point, what stands between the group and RSO status. Finding Hastings' open access condition on RSO status reasonable and viewpoint neutral, we reject CLS's free speech and expressive association claim. At the conclusion, Kennedy concurs, Alito, Scalia, Thomas, and the Chief Justice dissent, and their dissent is four and a half pages long, so I can't record it right now.